Will the House come to order and members kindly take their seats? Good morning. The devotional today will be led by Amelia Struthers and Representative Mike Marwicki of Putney.
Good morning. One of the things I've learned from my years here is just about everyone I've talked to about why they're here and what inspired them to want to serve is their love for the state and their love for the people of Vermont. So this is I'd call this a little love song for Vermont that we wrote together. Comes on the air. You'd think fires and fights were all there was to share. But I know, no it isn't so. I know there's people who care. Here in Vermont, we still come together. And here in Vermont, we love the land and of course each other. When it gets cold, we'll be fine, 'cause we can make our own sunshine. Flows from our hearts, we'll find in each part here in Vermont. Then one night, 12 a.m., the telephone rings. Never know what midnight calls will bring. The loss was huge, but family and friends came there to show how much they care. Here in Vermont, we still come together. And here in Vermont, we love the land and of course each other. And when it gets cold, we'll be fine, 'cause we can make our own sunshine. Flows from our hearts, we find in each part here in Vermont. Yeah, when it gets cold, we'll be fine, 'cause we can make our own sunshine. Flows from our hearts, we find in each part here in Vermont. Deep down anywhere, deep roots connected everywhere, connecting us to sea. We are the forest in every tree. Every night, news comes on the air. You'd think fires and fights were all there was to share. But I know, no it isn't so. I know there's people who care. Here in Vermont, we still come together. And here in Vermont, we love the land and of course each other. And when it gets cold, we'll be fine, 'cause we can make our own sunshine. Flows from our hearts, we find in each part here in Vermont. Yeah, when it gets cold, we'll be fine, 'cause we can make our own sunshine. Flows from our hearts, we find in each part here in Vermont. Here in Vermont. Here in Vermont. Here in Vermont.
Members, this morning we will honor a former House member who we recently lost. Representative Dean Corn of Burlington was born in 1955. He served in the House from 1993 to 2000 and passed away on Wednesday morning. Will you please rise and join me in a moment of silence in memory of Representative Corn? Members, we have two House bills on the notice calendar requiring a referral to a money committee pursuant to House Rule 35A. The first is Senate Bill 4, which is an act relating to reducing crimes of violence associated with juveniles and dangerous weapons. Carrying an appropriation, the bill is referred to the Committee on Appropriations. The second is Senate Bill 89, which is an act relating to establishing a forensic facility affecting the revenue of the state. The bill is referred to the Committee on Ways and Means. Members, we have received a request to read a House concurrent resolution that the House and the Senate adopted pursuant to the consent calendar. HCR 106 is a House concurrent resolution recognizing May 2023 as National Foster Care Month in Vermont. Please listen to the reading of the resolution.
Children deserve a safe, loving, and nurturing home. And whereas families serve as the primary support structure for personal identity and community connections, and whereas foster care nurtures family relationships and foster care providers help children and youth develop, and whereas in Vermont there are over 1,000 children and youth in the custody of the Department for Children and Families who are living with dedicated foster, kinship, and respite care providers in homes where the children's need for safety and belonging is ensured until their parents can safely resume family responsibilities. And whereas many foster families create permanency for children and youth through adoption when they cannot safely return to live with their birth families, and whereas foster care providers, in collaboration with public and private community partners, support the transition of youth and young adults to successful independence. And whereas May is National Foster Care Month and is an ideal occasion to raise awareness of foster care and to celebrate those individuals who are dedicated to serving our children, youth, and families. Now therefore be it resolved by the Senate and House of Representatives that the General Assembly recognizes May 2023 as National Foster Care Month in Vermont, and be it further resolved that the Secretary of State be directed to send a copy of this resolution to Vermont Foster Adoptive Family Alliance, Vermont Kinnis Parents, and the Vermont Commissioner for Children and Families.
Are there any announcements? Member from Northfield.
Madam Speaker, you have just heard the reading of the resolution about Foster Parent Month, and I'm very proud to rise in support of this resolution and to introduce some folks who are here today to have heard that reading. As a foster parent myself, I know the sacrifices and the gift that these families are making to these children who, for whatever reason, can't be in their own families and need tremendous love and support to make it through these very difficult times. I'm very proud of our Human Services Committee, who, in recognition of the fact that these are not paid positions, but the stipends they receive primarily go for clothing and food. We all know what inflation is like. And so we urged an increase in that minimal stipend that they receive. These are tremendous assets and supporters of families in our community. And so it's with great pleasure that I introduce to the body Chris Winters, who's our Department of Children and Families Commissioner, Erica Radke, DCF Deputy Commissioner, Carrie Dean, who's the DCF Foster and Kin Care Manager, Mary Collins, DCF Foster Parent Recruitment and Retention Specialist. Jim Holloway, a foster parent and board member of Vermont Kin as Parents, and his daughter, Elise. Lynn Messier, foster parent and Vermont Kin as Parents board member, and Tanya Kristen, who's the Green Mountain United Way Executive Director. Please join me in welcoming them.
Will the guest of the member from Northfield please rise and be recognized? Member from Essex.
Buenos dias, Madam Speaker. They say that the best things in life are free, but then I think about chocolate and vanilla, avocados, tomatoes, corn, beans, and then I go down the rabbit hole of tacos, tlacoyos, sopes, huaraches, and I think about Frida Kahlo, and I think about my mom, and I realize that the best things in life are Mexican. So I want to wish everybody a feliz Cinco de Mayo, and I wanted to share just a brief explanation of what it is, what it isn't. Cinco de Mayo is a uniquely American celebration. It's not a date widely observed in Mexico. It was selected as a date to celebrate Mexican culture in the American Southwest, where, as Mexicans in the Southwest say, the border crossed us, we didn't cross the border. All the way up to Montana, was all Greater Mexico until the 1840s, just 20 years after Mexico had finally fought the yoke of Spanish colonialist oppression. It lost half its territory to this country in a horrible land grab, not unlike what Putin has done to Ukraine. And 20 years after that, they were invaded again by the French. It was one of the most powerful armies in the world at the time, and it had alliances with the British, with the Spanish, and in case you were wondering which side of history was the right side of history in that battle, also with the Confederacy. In May of 1862, the French landed on Mexico's shores and proceeded to march inland. People armed with farming implements and tools and sticks fought off the globe's most powerful army and won that battle in Puebla on the 5th of May. They lost the war, however, because France quickly sent many, many more troops and reinforcements. And for 5 years, they installed a puppet dictator monarch in Mexico City. You can visit the castle today. They put it in the park where the last Aztec emperor had held his court, in case the symbolism could possibly be lost. And Mexican Americans in the Southwest who had been teaching children for decades being segregated in the 60s with the efforts in civil rights and desegregation in the Southwest, there was an effort to uplift and to inculcate pride rather than shame in Mexican children. And the date of Cinco de Mayo was chosen because of that historic significance of the date. Mexican Independence Day in Mexico is celebrated on the 16th of September. That's not a really great, if you are in education, you know that that is no time to throw a party in the classroom. So the 5th of May was chosen as a day, not of militaristic parades or anything like that, even though it was a military victory. It's a day of celebrating the joy and the beauty of things like chocolate and Frida Kahlo. So viva Mexico, viva Vermont, y gracias. And if you have any questions or how to party responsibly for Cinco de Mayo, I would just say the main thing is to do a little research. There's probably a lot that you don't know, and if you just ask the right questions, you will get a chance to learn. Book a vacation in Mexico somewhere other than the usual spring break places. Try a new food. Find a Mexican-owned restaurant in the area. There are many. Aranda's Mexican Cuisine in Barrie, just down down this highway. Grupo Viva el Sabor also caters delicious Mexican food for events. And of course, you could always donate to Migrant Justice or call a friend and ask any questions. So, muchas gracias.
Happy Cinco de Mayo. Member from Virgins.
Thank you, Madam Speaker. Along with the many harbingers of spring is the arrival of the craft beer delegation. These individuals are here for their annual Vermont tour. As unofficial ambassadors of beer, they take their roles very seriously, arriving yesterday. They've already met with the governor. Now they're stopping by to check in with the legislative branch. And next they will begin their work, traveling the state to visit our world-class breweries. And they're going to do their best to bring some last-minute revenue in and help settle any budget shortfalls the state may have. Please join me in welcoming Bruce Whistler, John Dewey, Jason Daly, and Matt Trout, Hoogterp, and wish them Godspeed as they begin their mission. Thank you, Madam Speaker.
Will the guest, the member from Virgins, please rise and be recognized? Member from St. Johnsbury.
Thank you, Madam Speaker. By a stroke of serendipity, I'm wearing my Mexican tie this morning, brought to me last Christmas by my son who was visiting Mexico. I wish I could say I planned it, but I'm not that good. Also, in recognition of the devotional, another unique thing here in Vermont is Green Up Day. Green Up Day is tomorrow. In fact, Vermont is the only state to hold an annual Green Up Day. My wife was stunned to learn a few years ago that it's not a national holiday. It's one of the most sacred days of the year for her. Other states have adopted highway programs. I have to admit to smirking when I see those signs along the road. Who are they kidding? Do they think the businesses who adopt that stretch of road actually come out and pick up litter? I seriously doubt it. Anyway, the first Green Up Day in Vermont was in 1971. They closed the interstates and had school kids and volunteers cleaning up the roadsides. Governor Davis hired 2 helicopters, one for him and one for the press, as I understand it, and dropped in around the state to help pick up trash and pose for pictures. Nowadays, of course, we pay VTrans staff to pick up trash along busy interstates and state roads, but regular folks fan out along local roads. Because she is away this weekend, my wife and I did some green up last Saturday. Members might be interested to know that more than half of what we picked up were returnable beverage containers worth a nickel each. That nickel deposit is unchanged since 50 years ago when Vermont's first bottle bill was passed. The idea was to combat litter, but that 1972 nickel is worth only 7/10 of a cent in today's money. Put another way, 5 cents in 1972 is about 35 cents today. The litter prevention incentive has faded somewhat, but I know legislators aren't in it for the money, so I hope members will be out there tomorrow helping to clean up litter after those thoughtless few who toss their trash on the roadsides. Thank you.
Member from Burlington.
Madam Speaker, as spring unfolds and as temperatures rise, I'd like to make a motion that all members, staff, and guests be permitted to remove any outer garments such as jackets, coats, robes, shawls, parkas, cloaks, capes, or what have you.
The member from Burlington moves that we suspend our rules in order to allow members to remove their jackets and other outer jacket-related item. You have heard the motion. Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. Nay. The ayes appear to have it. The ayes do have it, and you have suspended our rules in order to allow members to remove their jackets in the chamber. Are there any further announcements? Member from Halifax.
Madam Speaker, There's a mental health resource that I think more Vermonters could be aware of. The Crisis Text Line is free to use. It provides free 24/7 support via the medium that people use and trust the most, texting. You can text VT to 471-471, and that's not so hard to remember because 471 is right next to each other on your keypad. And a trained volunteer will talk you through whatever's going on. It's also a wonderful organization to volunteer for. They offer great training, and you can support people from the comfort of your home who are in crisis, just as long as you have an internet connection. So you can text VT to 741-741.
Are there any further announcements? Seeing none. Oh, member from Putney.
Thank you, Madam Speaker. I'd like to introduce to you and to the body my wife, Amelia, musical partner, life partner, and that person who does the hard work keeping the home fires burning so I can be up here so far from home to do this work here. I'd like to introduce her Amelia to the body.
Will the family of the member from Putney please rise and be recognized? Member from Waitsfield.
Thank you, Madam Speaker. Last night, I attended the annual meeting for Capstone Community Action, which is an entity that's been around since 1965, helping Vermonters across the region and the state rise out of poverty. And last night, the event was at the Vermont Granite Museum in Barre, and I was accompanied by a number of members of this House. There are a couple of members in particular that were called out at the event. One was, in fact, in recognition of the Wheels for Warmth, received an award for their ongoing work in helping the environment, people to achieve, access tires, as well as provide dollars for heating support. One particular person from the member from Northfield was acknowledged for his ongoing work in flipping burgers and roasting hot dogs for the event and recruiting volunteers and members. Another member of the House, the member from Morristown, received the highest award. That award was not only was she the keynote speaker, but an award as a person of the year in her work, her advocacy, and her ongoing commitment towards those that are working on their own efforts to become stable in their lives and to rise out of poverty. I want to just, if you would, encourage all of us to welcome and congratulate our members in this House. Thank you.
Congratulations. Thank you, members. Are there any further announcements? Member from Essex.
I almost forgot, Madam Speaker, that today is a birthday as well as Cinco de Mayo of one of our special representatives, one of my favorite committee mates, Representative Lally, from the member from Shelburne.
Happy birthday, member. Are there any further announcements? Seeing none, orders of the day. Members, we will begin with House Bill 81, which is an act relating to fair repair of agricultural equipment. Please listen to the third reading of the bill.
H81, an act relating to fair repair of agricultural equipment.
The question is, shall the bill pass? Member from Coventry.
Thank you, Madam Speaker. Just like to go over a few pieces of H81 so that everyone is well aware of what it does and what it doesn't do. H81 does not change the relationship between a customer and a dealer in the state. It doesn't It doesn't create manufacturers selling equipment and trying to cut out the dealers. It does not do that. It still allows the dealers to work closely with their customers in selling parts, documentation, as well as diagnostic and other tools needed to repair their equipment. What this does do is make sure that in the event that the dealers do not have the staff to be able to assist their customers in repairing their equipment in a timely manner, especially during times of providing or putting seeds in the ground, tilling the soil, out in the forest, cutting trees, that this allows them to be able to repair their own pieces of equipment that they bought, that they own, that in most cases have paid thousands, hundreds of thousands, and sometimes millions of dollars, repair their own equipment. We've made sure that emissions and safety issues still are maintained, that it is against the federal law to make any changes to the emissions. And now it's would be against state law as well in the Consumer Protection Act. That gives the Attorney General the ability to go after an individual or an individual repair person if they decide that they want to override those systems. Madam Speaker, this is an extremely important bill for our agriculture, for our farmers, for our foresters, to be able to keep their equipment going when they need to get the work done. So this being such an important bill to our agricultural community in Vermont, I ask that when the vote is taken, it be taken by roll. Thank you.
The member from Coventry requests that when the vote is taken, it be taken by roll. Is the member sustained? The member is sustained. When the vote is taken, it will be taken by roll. Member from Brownington.
Thank you, Madam Secretary. No? Madam Speaker, I'm sorry. I need to make a correction for my report yesterday. I reported the straw poll vote in my committee incorrectly. The actual straw vote was 8-1. And in addition, I'd also like to thank the Commerce Committee from the Agricultural Committee for their hard work. Thank you.
The question is, shall the bill pass? Are you ready for the question? If so, will the clerk please call the roll?
Andrews of Westford.
2 minutes. Will the House please come to order and members kindly take their seats? Will the House please come to order? I would like to remind members that we are in the middle of a roll call vote. Members and guests are prohibited from using computers, phones, or any type of an electronic device. Please refrain from the passing of notes and conversations during a roll call. When the clerk calls your name, please answer in a loud and clear voice so the clerk can accurately record your vote. The question is, shall the bill pass? Will the clerk please continue to call the roll?
Anthony of Berry City. Yes. Arison of Weathersfield. Yes. Arsenault of Williston. Yes. Austin of Colchester. Yes. Bartholomew of Heartland. Yes. Bartley of Fairfax. Yes. Beck of St. Johnsbury. Yes. Rebecca of Winooski. Yes. Byrong of Virgins. Yes. Black of Essex. Yes. Bloomley of Burlington. Yes. Bongarts of Manchester. Yes. Boslin of Westminster. Yes. Boyden of Cambridge. Yes. Brady of Williston. Yes. Brannigan of Georgia. Yes. Brennan of Colchester. Yes. Brown of Richmond. Yes. Brownell of Pownell. Brumstead of Shelburne. Yes. Burdett of West Rutland. Burke of Brattleboro. Yes. Burrows of West Windsor. Yes. Buss of Woodstock. Yes. Campbell of St. Johnsbury. Yes. Canfield of Fairhaven. Yes. Carpenter of Hyde Park. Yes. Carroll Bennington. Yes. Casey of Montpelier.
Yes.
Chapin of East Montpelier. Yes. Chase of Chester. Yes. Chase of Colchester.
Yes.
Chestnut Tangerman of Middletown Springs.
Yes.
Christie of Hartford.
Yes.
Chena of Burlington. Yes. Clifford of Rutland City. Yes. Coffey of Guilford. Yes. Cole of Hartford. Yes. Conlon of Cornwall.
Yes.
Corcoran of Bennington.
Yes.
Cordes of Lincoln.
Yes.
DeMar of Enosburg.
Yes.
Demro of Corinth.
Yes.
Dickinson of St. Albans Town. Dodge of Essex. Dolan of Essex Junction. Dolan of Waitsfield. Donahue of Northfield. Durfee of Shaftesbury. Elder of Starksboro. Emmons of Springfield. Farlese Rubio of Barnet. Galfetti of Berrytown. Garifano of Essex. Goldman of Rockingham. Ghostland of Northfield. Graham of Williamstown. Granning of Jericho. Gregoire of Fairfield. Hengo Berkshire. Harrison of Chittenden. Hedrick of Burlington. Higley of Lowell. Holcomb of Norwich. Hooper of Randolph. Hooper of Burlington. Houghton of Essex Junction. Howard of Rutland City. Hyman of South Burlington. James of Manchester. Jerome of Brandon. Jerome of Brandon. Kornheiser of Brattleboro. Krasnow of South Burlington. Labor of Morgan. LaBounty of Linden. Lally of Shelburne. Lalone of South Burlington. Lamont of Morristown. Lanford of Virgins. LaRush of Franklin. Levitt of Grand Isle. Lipsky of Stowe. Logan of Burlington. Long of Newfane. McGuire of Rutland City. Marcotte of Coventry. Maslin of Thetford. Matos of Milton. McCann of Montpelier. McCarthy of St. Albans City. McCoy of Pulteney. McFawn of Berrytown. McGill of Bridport. Mahaly of Calais. Minier of South Burlington. Morgan of Milton. Morris of Springfield. Morrissey of Bennington. Rowicki of Putney. Mulvaney Stanek of Burlington. Nicole of Ludlow. Knott of Rutland City. Noyes of Wolcott. Nugent of South Burlington. O'Brien of Tunbridge. Odie Burlington. Oliver of Sheldon. Page of Newport City. Pyala of Londonderry. Parsons of Newberry. Pat of Worcester. Pearl of Danville. Peterson of Clarendon. Pouch of Heinsberg. Priestley of Bradford. Rachelson of Burlington. Rice of Dorset. Roberts of Halifax. Samus of Castleton. Sakowitz of Randolph. Shai of Middlebury. Shaw of Pittsford. Sheldon of Middlebury. Sibilia of Dover. Sims of Craftsbury. Small of Winooski. Smith of Derby. Squirrel of Underhill. Stebbins of Burlington. Stevens of Waterbury. Stone of Burlington. Supernon of Barnard. Taylor of Milton. Taylor of Colchester. Templeman of Brownington. Toledo of Brattleboro. Toof of St. Albans Town. Torrey of Moortown. Troiano of Stannard. Walker of Swanton. Waters Evans of Charlotte. White of Bethel. Whitman of Bennington. Williams of Berry City. Williams of Granby. Wilson of Linden. Wood of Waterbury. Brownell of Pownell. Burdett of West Rutland. Dickinson of St. Albans Town. Emmons of Springfield. Garifano of Essex. Hango of Berkshire. James of Manchester. Lamont of Morristown. Lanford of Virgins. McCoy of Pulteney. McFawn of Berrytown. And Wilson of Linden.
For purpose of explanation, member from Bradford.
Madam Speaker, when we increase people's choice, we increase competition and decrease exploitation.
Member from Bennington. Dorset.
We heard the powerful voices of Vermonters, farmers, loggers, and mechanics telling us about the positive impact the right to repair will have for them and our rural communities. Fair repair is a growing movement here in Vermont and across the country that basically says we should have the right to fix our stuff when it breaks. It's hard to think of a better group with whom to start ensuring that right than Vermont's farmers. For them, I was proud to vote yes.
Member from Craftsbury.
If you own something, you have the right to fix it. I voted yes on this bill to require manufacturers to make the tools, manuals, and diagnostic equipment available to our farmers and loggers. I voted yes so there'll be more options for consumers in Vermont.
A member from Barnard.
Madam Speaker, I voted yes today to support my agricultural community. As a farmer, I am well versed in the challenges that come with working the land. We are at the whim of weather, fluctuating markets, and daylight. So much is out of our hands. H81 is an important step towards giving our farmers just a little bit of ease for something we can control, and that's the right to repair our equipment. Thank you.
Members, please listen to the results of your vote. Those voting yes, 139. Those voting no, 2. The ayes have it, and you have passed the bill. Members, please listen to the results of your vote again. Those voting yes, 137. Those voting no, 2. The ayes have it, and you have passed the bill. Members, just to give you an update on our calendar and the bill order, we will take up next S94, followed by H21, followed by H230. With that, Next is Senate Bill 94, which is an act relating to the City of Barry Tax Increment Financing District. Please listen to the third reading of the bill.
S94, an act relating to the City of Barry Tax Increment Financing District.
The question is, shall the bill pass in concurrence with proposal of amendment? Are you ready for the question? Member from St. Albans City.
Madam Speaker, yesterday I meant to rise with support, especially with the amendment that had been offered yesterday by the chair of House Commerce and Economic Development. I think it's a great improvement to just clarify that we need to have an announcement and a warning when executive session is going to happen in meetings. It's the practice for most open meetings today, or meetings that are subject to the open meeting law, and it's an improvement to this bill.
The question is, shall the bill pass in concurrence with proposal of amendment? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have passed the bill in concurrence with proposal of amendment. Now we'll turn to House Bill 21, which is an act relating to landlord notice of utility disconnections. The bill was referred to the Committee on General and Housing, which recommends that the bill be amended as printed in today's calendar. The member from Morgan, Representative Labor, will speak for the committee. Please listen to the second reading of the bill.
Thank you, Madam Speaker.
Member, we need to read the second reading of the bill. One moment.
H21, an act relating to landlord notice of utility disconnections.
And now member from Morgan.
Thank you, Madam Speaker. Today I am reporting H21 as amended by the Committee on General and Housing. It is on your calendar, and it's on page 2794 if anyone cares to follow. It is an act relating to landlord notice of utility disconnections. It is for the purpose of promoting safety, protection of property, and providing assistance to tenants and landlords. The Public Utility Commission shall revise its rules concerning utility service disconnections to require notice to property owners of residential and non-residential rental properties when the utility has been disconnected, even if the tenant is the ratepayer. This would allow the utility to disconnect remotely. Utility service is defined as gas, electric, water, and wastewater that is subject to the jurisdiction of the Public Utility Committee. The rules shall establish form, content, time, and the manner of notification as required by subdivision A1 of this section, and shall include a process whereby the property owner may request the notification be sent to the property manager or other appropriate third party. The rules shall ensure that the notification does not include personal or confidential information pertaining to the tenant or tenant's account, except that the utility may enclose information necessary to enable the property owner or other applicable third party to reconnect the utility service to the property. On or before January 15th, 2024, the Public Utility Commission shall submit to the following committees: House Committees on General and Housing and on Environment and Energy, and the Senate Committees on Economic Development, Housing and General Affairs, and on Finance, a proposal in the form of draft legislation that incorporates, as the Commission deems appropriate, the rules adopted by the Commission pursuant to this section, and that applies to utility disconnections not subject to the jurisdiction of the commission, including water, sewer service provided by a water and sewer system owned by a municipality, fire district, or private company, subject to the uniform water and sewer disconnection requirements in 24 VSA Chapter 129. Our list of witnesses goes as follows. Manager of Government Affairs and Member Relations from Vermont Electric Co-op, Consumer Affairs Director, Department of the Public Service, the bill's sponsor, General Manager of Washington Electric Co-op, Legislative Counsel and Office of Legislative Counsel, Property Manager from Magog Rentals. Our committee voted out favorably, 10-0-1. We request your support for this bill. Thank you.
The question is, shall the bill be amended as recommended by the Committee on General and Housing? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have amended the bill. Now the question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. Now we will turn to House Bill 230, which is an act relating to implementing mechanisms to reduce suicide. The bill passed the Senate with a proposal of amendment that is printed in today's calendar. The pending question is, shall the House concur in the Senate proposal of amendment? Member from South Burlington.
Madam Speaker, H 230, which can be found on page 2845 of today's calendar, is the Senate strike-all proposal of amendment. H 230 contains several provisions related to reducing suicide by firearm and reducing community violence. The findings in Section 1 document the connection between suicide and access to firearms, and the statement of purpose in Section 2 explains that the purposes of H 230 are to prevent death by suicide by reducing access to operable firearms by children and prohibited persons, and to reduce community violence. As passed the House, the title and purpose section in Section 2 of H 230 referred only to reducing suicide, but the Senate amended the purpose to include reducing community violence, which more accurately reflects the contents of the bill. Section 3 establishes the crime of negligent firearms storage. The substance of the Senate amendment is similar to the substance of the House bill with a few modifications. The Senate believed that the better approach was to mirror the title and structure of a related New Hampshire statute. While the House bill called this section secure firearm storage, the Senate renamed it negligent firearm storage. Under subdivision A1, a person commits the crime of negligent firearm storage if certain harms result because that person keeps or stores firearms in any premises under the person's custody or control, and the person knows or reasonably should know that a child or prohibited person is likely to gain access to the firearm. A prohibited person is someone who is prohibited by law from possessing a firearm. If the resulting harm is that a child or a prohibited person gains access to the firearm and uses it to commit a crime or displays it in a threatening manner, the person who stored or kept the firearm may be imprisoned not more than 1 year or fined not more than $1,000 or both, which matches the penalty that was in the House-passed version. If the resulting harm is that a child or a prohibited person gains access to the firearm and uses it to cause death or injury to any person, The person who stored or kept the firearm may be imprisoned not more than 5 years or fined not more than $5,000 or both. If none of these listed harms occur, then no crime has occurred, and the person who stored or kept the firearm cannot be charged for having known or should have known that a child or prohibited person could have gained access to the firearm. Several exceptions to the crime listed in subdivision 2 are retained from what passed the House. First, there is no crime if the firearm is carried by or within such close proximity that it can be readily retrieved and used by the owner or another authorized user. Second, there is no crime if the child or prohibited person accesses the firearm during an illegal entry or while acting in self-defense or defense of another person. Lastly, there is no crime if the person stores or keeps the firearm in a locked container or equipped with a tamper-resistant mechanical lock or other safety device. The Senate removed House language that also required the firearm to be stored separately from ammunition because the Senate Judiciary Committee's view was that keeping the firearm in a safe or equipped with a trigger lock is a safe means of storage, even if the firearm is not kept separate from the ammunition. If any of these exceptions apply, the person cannot be charged with a crime, even if a child or prohibited person accesses the firearm and uses it to cause one of the listed harms. Section 3 also requires firearms dealers to post signs where they conduct sales that warn purchasers about the risks of firearms and suicide, and that inform purchasers about the need to securely store firearms and the importance of seeking firearm safety instruction. The Senate modified the text of the warning slightly based on the New Hampshire statute's warning provision. In addition, the House version of Section 3 included language providing that state's attorneys have discretion about whether to charge a person with a crime for violating the negligent storage statute. But the Senate struck this language because it is unnecessary. State's attorneys already have this discretion. Sections 4 to 6 involve the procedures for obtaining an extreme risk protection order, also known as an ERPO. In Section 5, based on testimony from the Attorney General's Office and Department of State's Attorneys in the Senate, the language was changed to provide that a state's attorney of the county where the petition was filed and not the Attorney General will be substituted as the plaintiff in an action once a family member seeks an ERPO. The same change is made in Section 6 when a family member obtains an emergency ERPO. In Section 6, the Senate also changed the ERPO provision regarding the standard of proof. Currently, a court will issue an emergency 14-day extreme risk protection order if it finds by a preponderance of the evidence that the defendant is dangerous. It will follow up by issuing a final 6-month ERPO if it finds by clear and convincing evidence that the defendant is dangerous. While the Senate agreed with the House to permit family and household members to file a petition, the Senate Judiciary Committee felt that the standard of proof should be greater for their petitions. For that reason, language was added requiring the court to find that the defendant is dangerous by clear and convincing evidence before granting a petition filed by a family and household member, even if it seeks an emergency order. The Senate made no changes to Section 7, which requires a 72-hour waiting period for most firearms transfers. The waiting period is not required for firearms transfers that do not require a background check, such as transfers between immediate family members, law enforcement, or the military. Section 8 is a severability section that was added by the Senate. It provides that if any section of the act is found invalid by a court, for example, by being found unconstitutional, that finding will not affect any other provisions of the act. The vote in the Judiciary Committee to concur with the Senate proposal of amendment was 6-5. In some respects, the version of H.230 passed by the House contained somewhat stronger protections. But under the Senate version, we would still have a firearms storage law where we haven't had one before. Families would be able to directly petition the court for an extreme risk protection order where they couldn't do so before. And critically, the Senate did not touch the 72-hour waiting period. This is an important step in our continuing efforts to address firearm violence in Vermont, particularly related to suicides. We ask for your support.
Member from Essex.
Thank you, Madam Speaker. Your Committee on Healthcare also did an overview of the Senate proposal for amendment. On a vote of 7-3-1, we agreed to concur with the Senate. Thank you.
The question is, shall the House concur in the Senate proposal of amendment? Are you ready for the question? Member from Lowell.
Roll call, Madam Speaker.
The member from Lowell requests when the vote is taken, it be taken by roll. Is the member sustained? The member is sustained. When the vote is taken, it will be taken by roll. Member from Newberry.
Thank you, Madam Speaker. May I interrogate the presenter from Judiciary?
The member from South Burlington is interrogated.
Thank you, Madam Speaker. I'm just trying to understand, to make sure I'm clear on this language. If this passes, would a parent be able to declare their child not prohibited from accessing the firearms?
My understanding is a child could use a firearm with permission if they're otherwise permitted to do so, yes.
So a parent could declare their child not prohibited?
I don't think it's I wouldn't use that language necessarily, declaring a child not prohibited as much as providing permission. So a child can use their firearm to go hunting, et cetera.
Okay, so that would mean they wouldn't fall under child or prohibited person as when it comes to accessing the firearm?
So if the child gets the firearm without permission and causes the harm that's laid out, then the owner of the firearm, or the premises, I should say, would be liable or potentially liable.
But if I've said that my child is allowed to access the firearm, then it's not illegal?
That is my understanding, yes.
Okay, thank you.
The question is, shall the House concur in the Senate proposal of amendment? Are you ready for the question? If so, will the clerk please call the roll?
Andrews of Westford.
2 minutes. Will the House please come to order and members kindly take their seats? I would like to remind members that we are in the middle of a roll call vote. Members and guests are prohibited from using computers, phones, or any type of an electronic device. Please refrain from the passing of notes and conversation during a roll call. When the clerk calls your name, please answer in a loud and clear voice so the clerk can accurately record your vote. The question is, shall the House concur in the Senate proposal of amendment? Will the clerk please continue to call the roll?
Andriano of Orwell. Anthony of Berry City. Harrison of Weathersfield. Arsenault of Williston. Austin of Colchester. Bartholomew of Heartland. Bartley of Fairfax. Beck of St. Johnsbury. Rebecca of Winooski. Byrong of Virgins. Black of Essex. Bloomley of Burlington. Bongarts of Manchester. Boslin of Westminster. Boyden of Cambridge. Brady of Williston. Brannigan of Georgia. Brennan of Colchester. Brown of Richmond. Brownell of Pownell. Brumstead of Shelburne. Burdett of West Rutland. Burke of Brattleboro. Burrows of West Windsor. Buss of Woodstock. Campbell of St. Johnsbury. Canfield of Fairhaven. Carpenter of Hyde Park. Carroll of Bennington. Casey of Montpelier. Chapin of East Montpelier. Chase of Chester. Chase of Colchester. Chestnut Tangerman of Middletown Springs. Christie of Hartford. Chena of Burlington. Clifford of Rutland City. Clifford of Rutland City. Thank you. Coffey of Guilford. Cole of Hartford. Conlon of Cornwall. Corcoran of Bennington. Cordes of Lincoln. DeMar of Enosburg. Demereux of Corinth. Dickinson of St. Albans Town. Dodge of Essex. Dolan of Essex Junction. Dolan of Waitsfield. Donahue of Northfield. Durfee of Shaftesbury. Elder of Starksboro. Emmons of Springfield. Farley's Rubio of Barnet. Galfetti of Berry Town. Garifano of Essex. Goldman of Rockingham. Ghostland of Northfield. Graham of Williamstown. Granning of Jericho. Gregoire of Fairfield. Hango of Berkshire. Harrison of Chittenden. Hedrick of Burlington. Higley of Lowell. Holcomb of Norwich. Hooper of Randolph. Hooper of Burlington. Houghton of Essex Junction. Howard of Rutland City. Hyman of South Burlington. James of Manchester. Jerome of Brandon. Kornheiser of Brattleboro. Krasnow of South Burlington. Labor of Morgan. LaBounty of Linden. Lally of Shelburne. Lalonde of South Burlington. Lamont of Morristown. Lanford of Virgins. LaRush of Franklin. Levitt of Grand Isle. Lipsky of Stowe. Logan of Burlington. Long of Newfane. McGuire of Rutland City. Marcotte of Coventry. Maslin of Thetford. Matos of Milton. McCann of Montpelier. McCarthy of St. Albans City. McCoy of Pulteney. McFawn of Berry Town. McGill of Bridport. Mahaly of Calais. Minier of South Burlington. Morgan of Milton. Morse of Springfield. Morrissey of Bennington. Rowicki of Putney. Mulvaney Stanek of Burlington. Nicole of Ludlow. Knott of Rutland City. Noyes of Wolcott. Nugent of South Burlington. O'Brien of Tunbridge. Odie of Burlington. Oliver of Sheldon. Page of Newport City. Payala of Londonderry. Parsons of Newberry. Pat of Worcester. Pearl of Danville. Peterson of Clarendon. Pouch of Heinsberg. Priestley of Bradford. Rachelson of Burlington. Rice of Dorset. Roberts of Halifax. Samus of Castleton. Sakowitz of Randolph. Shai of Middlebury. Shaw of Pittsford. Sheldon of Millbury. Sibilia of Dover. Sims of Craftsbury. Small of Winooski. Smith of Derby. Squirrel of Underhill. Stebbins of Burlington. Stevens of Waterbury. Stone of Burlington. Supernaught of Barnard. Taylor of Milton. Taylor of Colchester. Templeman of Brownington. Toledo of Brattleboro. Toof of St. Albans Town. Torrey of Moortown. Troiano of Stannard. Walker of Swanton. Waters Evans of Charlotte. White of Bethel. Whitman of Bennington. Williamsbury City. Williams Granby. Wilson of Linden. Wood of Waterbury. Brownell of Pownell. Burdett of West Rutland. Chase of Colchester. Dickinson of St. Albans Town. Garifano of Essex. Hengo of Berkshire. James of Manchester. McCoy of Pulteney. McFawn of Barrytown. Payala of Londonderry. And Wilson of Linden.
For purpose of explanation, member from Orwell.
Thank you, Madam Speaker. Under the new test put forth by the United States Supreme Court in New York State Rifle and Pistol Association Incorporated versus Bruin, I believe this bill is unconstitutional. The Senate did not fix the constitutional issue, which is why I voted no.
Member from Williston.
I vote yes for H230 because this bill represents progress in the battle against the epidemic of gun violence in our state and country. I hope for continued progress in this deadly struggle so that we may reverse the trends and poisonous culture that have led us to this point. I hope for a day when guns are no longer the #1 killer of children in this country.
Member from Williston.
Madam Speaker, with this legislation, we can better prevent unauthorized access to firearms, particularly by youth. Yesterday, your House Education Committee passed a school safety bill, and certainly this is another critical step to keep our schools and all of our kids safe.
Member from Essex Junction.
Madam Speaker, the data is clear. Vermont's suicide rate continues to increase, and our rate is significantly higher than the rest of the U.S. Vermonters have died because in one impulsive act, they gained access to a firearm. I vote yes, because our actions will save lives.
And the other member from Essex Junction.
Thank you, Madam Speaker. I should know to yield to the senior member from Essex Junction, so. I vote yes. Vermonters deserve the common sense protections offered in H230. Our support will save lives.
A member from Northfield.
Thank you, Madam Speaker. Madam Speaker, I have supported gun bills in the past when they're data-driven, showing a protective impact that outweighs the burden on legitimate gun ownership and that meets the test for constitutionality. This one meets none of those standards.
Member from Rutland City.
I voted for H230 in committee and on the House floor and voted to concur today because of the importance of this bill. Suicide for Vermont males is 50% higher than the national average. Vermonters living in rural areas, veterans, Vermonters with disabilities, and LGBTQ+ Vermonters are all at greater risk of suicide. A child in a home with a firearm is 4.4 times more likely to die by suicide. This is all terrible and deeply alarming. We simply cannot do nothing. Vermonters deserve better.
Member from Castleton.
Madam Speaker, when we have to begin introducing legislation that has special sections within it in order to keep the rest of the bill from falling apart due to the impending idea of future litigation due to the egregious violation of civil liberties, and half your own committee is against it, you might have a bad piece of legislation. Leave the civil liberties of Vermonters alone, period. Thank you.
Member from Berry City.
I vote yes for my childhood friends, Bucky and Tyler, now deceased. Thank you.
Member from Granby.
I took an oath of office to uphold the Constitution. I believe this bill infringes upon the constitutional rights of Vermonters. More importantly, I believe it will not make a dent in reducing suicide. We must focus on root cause. We are missing the mark by a long shot.
Member from Burlington.
Madam Speaker, may I explain my vote?
You may.
Our communities are in crisis, and easy access to guns hurts all of us. Whether we are experiencing a mental health crisis, going about our regular day in grocery stores, churches, mosques, synagogues, or simply trying to attend school. We cannot stand by anymore. We must act. It is our responsibility as leaders. I vote yes for H230 to create safer communities for all of us.
Member from Stannard.
Madam Speaker, may I explain my vote?
You may.
Madam Speaker, I voted yes. We know that a disproportionate number of veterans die of suicide by firearm every day. If this law saves one life, it is worth it to me. Thank you.
Members, please listen to the results of your vote. Those voting yes, 106. Those voting no, 34. The ayes have it, and you have concurred in the Senate proposal of amendment. Members, we will now resume the order of the calendar with S47, S95, and then if time, JRS 17. With that, we'll turn to Senate Bill 47, which is an act relating to the transport of individuals requiring psychiatric care. The bill was referred to the Committee on Health Care, which recommends that the House propose to the Senate to amend the bill as printed in today's calendar. The member from Clarendon, Representative Peterson, will speak for the committee. Please listen to the second reading of the bill.
S47, an act relating to the transport of individuals requiring psychiatric care.
Member from Clarendon.
Thank you, Madam Speaker. Bill S47 clarifies and expands existing statute concerning temporary custody and transportation of a person having a mental health crisis. When a person is determined to be a danger to himself or others, it is critical that efficient, updated laws and procedures are in place for the safety of our service professionals, the public, and the person in crisis. There are 7 substantive changes to 18 Vermont statutes annotated proposed in the bill that will make those improvements. I will go over them now. First, it amends existing language concerning observation of a person in crisis. While present law only allows for personal observation by law enforcement or mental health professionals in order to apply for a warrant, new language in this bill would also allow a statement of fact from any person who personally observes the crisis as reason to get a warrant. This section was added by our Healthcare Committee. Second, it amends existing law to allow only law enforcement officers and not a mental health professional to take a person into temporary custody if the law enforcement officer has probable cause to believe that the person poses a risk of harm to self or others. Third, it codifies the warrant application and transportation processes while a person is in temporary custody. Fourth, it amends existing laws so that only law enforcement may transport a person to a hospital after a judge issues a warrant. Fifth, it adds a new subsection that specifies that authority to transport a person in crisis expires if the person is not taken into custody and transported within 72 hours after a warrant is issued. This, again, is added by your healthcare committee. Sixth, it adds language that a law enforcement vehicle must have soft restraints available to use as a first option when transporting a person in the custody of the Commissioner of Mental Health. And seventh, by January 1, 2024, the Department of Mental Health, in consultation with a number of stakeholders, is required to submit a report to the General Assembly containing any proposed changes to the warrant process in 18 VSA Section 7505, including mechanisms to reduce safety risk and reduce delays in accessing care. So now at this point, I want to walk through the sections of this strike all amendment, which can be found on page 2795 of today's calendar. The first section of the bill also is the first item I list as a substantive change to statute, talks about how we take a person into custody and the change, and I'll read it. It's at the bottom of page 2795. The application shall be based on facts personally observed by mental health professionals or law enforcement officers, which is present statute, or shall be supported by statement of fact under penalty of perjury by a person who has personally observed the facts that form the basis of the application. So what this means is there'll be a form filled out by a person, an affidavit, which he or she will sign and submit as reason to take the person into temporary custody. Part B1 is the second change that we're making. The law enforcement officer, but not the mental health professional, which is lined out, may take the person into temporary custody. That's a change in statute. And then the third substantive change is next. If the law enforcement officer has probable cause to believe that the person poses a risk of harm to self or others, the law enforcement officer or mental health professional may apply to the court for the warrant without delay while the person is in temporary custody. The law enforcement officer or mental health professional, if clinically appropriate, may then transport the person if the law enforcement officer or mental health professional conducting the transport has probable cause to believe that the person poses a risk of harm to self or others. So this process is before there is a warrant issued by a judge, all of this. And number two below that, B2, transport conducted pursuant to this subsection will provide individuals the same protection as provided to individuals in the custody of the commissioner who are transported pursuant to section 7511 of this title. We'll talk about 7511 in a minute. So all that I've gone over so far happens before the warrant is issued. Now from C down is after there's been a warrant issued. So D1 is the fourth substantive change. If necessary, the court may order the law enforcement officer and previous to this or existing today or mental health professional, we took that out. So only the law enforcement officer would transport the person to a hospital. This is a signed warrant by a judge saying that the individual needs an examination. So law enforcement would take them to the hospital. Down to E, which is the fifth change we make. Authority to transport a person pursuant to this section will expire if the person is not taken into custody and transported within 72 hours after the warrant is issued by a superior judge. So today, there's no limit on the time of a warrant. It goes on forever, and you could take a person who has no longer had the crisis and take them into custody. So this sets the bar at 72 hours. I'm going to skip over to section 2 of the bill and hit some of the highlights of it. The transportation section. This spells out, if you look back on 2, on page 2796, 2 talks about transportation shall be provided to individuals the same protection as provided in 7511. 7511 talks about that. And the manner of transport will prevent physical and psychological trauma, respect the privacy of the individual, and and represent the least restrictive means necessary for the safety of the patient. And down to D is something we have added in, or that the bill has, is the last piece of it. A law enforcement vehicle shall have soft restraints available for the use as a first option, and mechanical restraints shall not be used as a substitute for soft restraints if the soft restraints are otherwise deemed adequate for safety. So that's another part of the bill. And then the 7th substantive change is below that. On or before January 15, 2024, the Department of Mental Health, with all the listed stakeholders, shall submit a report to the House Committees on Healthcare and on Judiciary and the Senate Committees on Health and Welfare on Judiciary containing any proposed changes to the warrant process. The effective date, July 1, 2023. The committee heard from the following witnesses: Legislative Counsel, Office of Legislative Counsel, General Counsel, Department of Mental Health, Program Director of Access and Acute Care, Claire Martin Center, Director of Mental Health Services, Vermont Care Partners, Coordinator, Team 2, Director of Mental Health Programs, Department of Public Safety, Assistant Director, First Call of Chittenden County and Community Outreach, Howard Center, Founder of Mad Freedom, Director of Mental Health Law Project, Vermont Legal Aid, and the Sheriff, Lamoille County, Vermont Sheriff's Association. The committee vote was 11-0-0, and we ask for the body's support.
The question is, shall the House propose to the Senate to amend the bill as recommended by the Committee on Health Care? Member from Northfield.
Madam Speaker, I rise in support of this bill, and in particular to speak about and address one really critical, long overdue subsection that was changed. Madam Speaker, in 2005, I came to this floor. I guess we were being a little less strict at the time about bringing props. I had a large blown up picture of a 10-year-old boy walking from a sheriff's car into the Brattleboro retreat. He had not just handcuffs, but a belly chain around his waist and chains around his ankles. Because at the time we had no restrictions, and it was an automatic policy of our sheriff's departments at the time, whenever they were doing a transport, to use full shackles. This boy was not struggling. He was not objecting to the transport. His father was able to take that picture as a record, and it changed the law in Vermont. But since that time, it has only applied to sheriffs. Madam Speaker, when a person is in a crisis, they are not a criminal, and they shouldn't be treated by one, and they shouldn't be publicly displayed as one. This change in policy has been successful and not a problem in the sheriff's department for many years. And in fact, it it includes that if it's necessary for safety, there may need to be more restrictive measures, but when it's not necessary, there should never be. We should be treating people with respect. We should be protecting their privacy, and we should not treat them as criminals. So I am very, very pleased to see this step taken to apply this requirement to all of our law enforcement. And I urge support for the bill. Thank you.
The question is, shall the House propose to the Senate to amend the bill as recommended by the Committee on Health Care? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have proposed to the Senate to amend the bill. Now the question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. Next is Senate Bill 95, which is an act relating to banking and insurance. The bill was referred to the Committee on Commerce and Economic Development, which recommends that the House propose to the Senate to amend the bill as printed in today's calendar. The member from Jericho, Representative Granning, will speak for the committee. Affecting the revenue of the state, the bill was then referred to the Committee on Ways and Means, which recommends that the bill ought to pass in concurrence with proposal of amendment recommended by the Committee on Commerce and Economic Development. The member from Berry City, Representative Anthony, will speak for that committee. Please listen to the second reading of the bill.
S95, an act relating to banking and insurance.
Member from Jericho.
Madam Speaker, S95 is the annual housekeeping bill initiated by the Department of Financial Regulation. The department provides oversight for banking, captive insurance, and securities. They are committed to protecting consumers against unfair and unlawful business practices, as well as ensuring that entities who are licensed to provide these services remain financially healthy and able to serve their customers. While there are many technical updates in this bill that clarify legislative intent, codify existing practice, or bring the law up to date with current technology, there are also sections that are a change in the law and, of course, a study. There are 12 sections of the bill. They touch on many of the department's areas of regulation. I will briefly describe each of the 12 sections and what they aim to accomplish. S95 is a strike-all amendment from your Committee on Commerce and Economic Development. The bill can be found on page 2798 of today's journal if you would like to follow along. Section 1 is a technical amendment that updates the section lettering in the captive reinsurance amendment that became law in 2022. Section 2 clarifies the legislative intent of the Vermont Insurance Data Security Law and clearly states that only reinsurers who are domiciled outside of Vermont are exempt from data security requirements. Section 3 is another technical change that codifies existing practice by deleting language specifying that the department is responsible for returning bonding fees when an application is denied, since the fees are paid to a bonding company and not to the department. Section 4 updates 8 VSA 2759A so that a debtor can cancel a debt adjustment contract by email or first-class mail instead of by telegram. Section 5 codifies the department's current interpretation of applicable laws and rules concerning a lender. When a borrower is required to keep a sum on deposit as a condition of being granted a loan, that the effective interest rate shall not exceed the legal rate of interest in Vermont. Section 6 is in relation to property and casualty insurance rate regulation. It broadens current practice to match those around life and health insurance laws. Here we make clear that only non-proprietary supporting information will be open to public inspection. This will enhance the department's ability to evaluate compliance by allowing insurance companies to request confidential trade secret status for some supporting information. Section 7 relates to long-term care insurance notices for rate changes. Current law requires companies to inform consumers of requests for rate increases. This can cause confusion as the requests are usually for much higher amounts than the rate increases granted by the Department of Financial Regulation. We're amending the law so that consumers are informed of rate increases after they are approved, but at least 90 days before they are implemented. Section 7A expands confidentiality protections to include persons licensed, authorized, and registered under the Securities Act to match those protections currently granted to persons licensed to provide similar service from financial institutions and insurance companies under Title VIII. The language in Sections 8 and 9 comprises the largest part of this bill, 66 of the 84 pages, and codifies current practice concerning the Vermont Life and Health Insurance Guarantee Association. The purpose of this association is to protect long-term care policyholders and beneficiaries in the event of an insurance company insolvency. In such event, the Association of Insurers would guarantee the payment of benefits and the continuation of coverage for policyholders subject to certain statutory limits. Under current law, both a Life and Health Insurance Guarantee Association and a Health Maintenance Organization Guarantee Association are to be created. However, the HMO Guarantee Association was never formed. This section proposes to merge the two associations into one, and then broadens the assessment base to include HMOs in the event of an insolvency. In addition, hospitals and fraternal benefit societies are excluded from membership in the association codifying current practice. Sections 10 through 12 concern Federal Home Loan Bank of Boston. I'll give some background here. The Boston location is one of 11 regional FHL banks chartered by Congress in 1932. It functions similarly to a credit union in that banks, credit unions, insurance companies, and community development financial institutions are eligible to join as members. FHL Bank Boston currently has 427 members in 6 New England states, including 32 members in Vermont. FHL Bank Boston can borrow funds in global capital markets at attractive rates and pass the benefit of such low-cost funds to members by making loans to them on very narrow margins. Due to disparities between federal banking law and state insurance law, loan options for Vermont insurance company members are less favorable than those given to Vermont banks and credit union members. Now we're back to the sections in the bill. Sections 10 through 12 change current law so that insurance company members may borrow money at more favorable terms by ensuring the FHL bank is a secured creditor. If an insurance company faces financial distress and a delinquency proceeding is initiated by the Commissioner of Financial Regulation, the FHL bank is exempted from voidable transfer and preference provisions in Vermont law. In addition, the time when the bank may secure its collateral is decreased from 90 days to not more than 10 days. Similar legislation has already become law in 24 states. Finally, our last section, 12A. We have a study that the Commissioner of Financial Regulation will conduct to determine whether the business practices of automobile insurance companies in Vermont are fair and reasonable. Through testimony, your Committee on Commerce and Economic Development heard that auto repair shops are often unable to pay their employees enough to remain fully staffed. When we dug deeper into this topic, we learned that auto insurance reimbursement rates are not covering the cost of repairs and that customers are having to pay more than their deductible to have their vehicles fixed. Testimony, not just this year, but also in past sessions, raised concerns about possible power imbalance between insurance companies, body repair shops, and consumers. After discussion with the DFR, we are requesting that they study this issue to help the legislature understand if additional regulation is necessary. The study requires the commissioner to look closely at several aspects of auto insurance, including labor reimbursement rates, appraisal practices, liability for insurer-controlled repair work, direct repair programs, consumer disclosures, regulations concerning claim settlement, betterment practices, the use of aftermarket and recycled parts in repairs, consumer complaints, and any other practices or acts or market conditions related to insurance coverage for auto repairs, and whether additional regulatory measures are necessary to prevent anti-competitive behavior and ensure the interests of all parties, especially consumers, are adequately protected. In addition, the study requires the commissioner to consider how the cost of auto repairs contribute to the price and availability of auto insurance in Vermont, and whether any new regulatory requirements recommended by the commissioner could impact the price and availability of auto insurance in Vermont. The commissioner is required to establish a procedure for soliciting and receiving stakeholder input. An interim progress report is due January 15th, 2024, and a final report containing the commissioner's findings and recommendations is due on November 15th, 2024. Section 13 specifies that the bill takes effect on July 1st, 2023. The House Committee on Commerce and Economic Development heard from a long list of witnesses. We heard from the Deputy Commissioner of Insurance, the Interim Deputy Commissioner of Banking, and the Director of Policy, all from the Department of Financial Regulation, General Counsel of the Federal Home Loan Bank of Boston, Government Relations Director of American Property and Casualty Insurance Association, Legislative Counsel, the owner of Bryan's Auto Repair, the owner of Clark's Collision Center, the owner of Jasmine's Auto Body, the owner of Parker's Classic Auto Works, President of the Vermont Bankers Association, Northeast Regional Vice President, National Association of Mutual Insurance Companies. This bill passed out of committee on a vote of 11-0-0. Your Committee on Commerce and Economic Development respectfully requests your support for this bill.
And now for the Committee on Ways and Means, member from Berry City.
Thank you, Madam Speaker. Our review of the bill reveals no discernible effect on state revenues, and on a straw vote, we found the proposal in S95 favorable on a vote of 12-0-0.
The question is, shall the House propose to the Senate to amend the bill as recommended by the Committee on Commerce and Economic Development? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have proposed to the Senate to amend the bill. Now the question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. Next is JRS 17, which is a joint resolution urging U.S. Citizenship and Immigration Services to comply with the expedited asylum hearing provisions of the Afghan Supplemental Appropriations Act of 2022. The resolution was treated as a bill and referred to the Committee on General and Housing, which recommends that the resolution ought to be adopted in concurrence. The member from South Burlington, Representative Krasnow, will speak for the committee. Please listen to the second reading of the resolution.
JRS 17, Joint Resolution urging U.S. Citizenship and Immigration Services to comply with the expedited asylum hearing provisions of the Afghan Supplemental Appropriations Act of 2022.
Member from South Burlington.
Madam Speaker, Joint Resolution 17 urges the U.S. Citizenship and Immigration Services to comply with the expedited process the U.S. established for Afghan nationals in acknowledgement of their work with the United States. The Afghan Supplemental Appropriations Act of 2022 included an expedited asylum review process with a deadline of final administrative action within 150 days. In the absence of extraordinary circumstances, more than 40 Afghan asylum applications have been filed by Vermont lawyers with no federal government response and no extraordinary circumstances. This resolution is intended to bring public attention to the harm that the USCIS bureaucratic inaction causes both the Afghans living in Vermont as well as the danger to the family members who remain in Afghanistan or are living as refugees in a third country. The resolution does not ask for special treatment, just that the U.S. government make good on its promise to its allies. Now I am going to read the resolution. JRS 17, Joint Resolution urging U.S. Citizenship and Immigration Services to comply with the expedited asylum hearing provisions of the Afghan Supplemental Appropriations Act of 2022. Whereas the final departure of American military personnel from Afghanistan in August 2021 meant that the Taliban would assume complete control of the Afghan government and society, greatly endangering Afghans and members of their families who worked for or were otherwise associated with the United States government. And whereas recognizing that the imminent departure would pose an immediate threat, the United States Department of Homeland Security established an evacuation and resettlement program known as Operation Allies Welcome that paroled certain Afghan nationals into the United States for the 2-year period. And whereas despite the activation of Operation Allies Welcome in the tumult of Americans' departure, may Afghans, including Hazaras, human rights activists, journalists, members of the LGBTQIA community, Shias, and other who are associated with the U.S. government were unable to depart. And whereas Congress also responded to this dire situation and adopted the Afghan Supplemental Appropriations Act of 2022. And whereas, as provided in Section 2502A of the Act, a citizen or national of Afghanistan or a person with no nationality who has last habitually resided in Afghanistan is entitled per Section 2502C to an expedited U.S. Citizenship and Immigration Services USCIS asylum review process, directing that the initial interview of the asylum application be conducted not later than 45 days after the application filing date, and that in the absence of the exceptional circumstances, USCIS shall use a final administrative injunction on the asylum application with 150 days after the date for the application is filed. And whereas the USCIS has not been observing the 150-day asylum decision deadline, even when the application does not present extraordinary circumstances. And whereas lawyers from the Association of Africans Living in Vermont and the U.S. Committee for Refugees and Immigrants Vermont have filed more than 40 Afghan asylum applications for which no federal government response has been received for a period longer than 150 days. And whereas Afghans living in the United States on parole status must have their own asylum application approved before petitioning for relatives who remain in Afghanistan or who have fled to Pakistan to be admitted to the United States. And whereas for Afghan asylum applicants residing in Vermont, the bureaucratic delay is preventing them from building new lives, but it is a life life-threatening for their family members who remain in Afghanistan or are living as refugees in a third country. Now, therefore, it be resolved by the Senate and House of Representatives that the General Assembly urges USCIS to comply fully with the accelerated asylum hearing provisions of the Afghan Supplemental Appropriations Act of 2022, and be it further resolved, the Secretary of State direct a copy of the resolution to USCIS Director M. Jadoo and to the Vermont Congressional Delegation. Our committee heard from the following witnesses. Legislative Counsel, Office of Legislative Counsel, the bill's sponsor from the Senate. Madam Speaker, your Committee on General and Housing passed the resolution on a vote of 10-02 and asked for your support.
The question is, shall the resolution be read a third time? Member from Orwell.
Thank you, Madam Speaker. I had to stand up and speak on this one because I think that we all watched in horror the videos, the footage that came out, particularly from around the airport, as the United States was leaving Afghanistan. But in my family, we watched in particular horror because my wife has many friends in Afghanistan and has done work in Afghanistan. And so we watched in particular horror because my wife had done some teaching at the School of Leadership in Afghanistan, which was the first and only girls' boarding school in Afghanistan. She actually traveled to India and taught a sort of off-site class for them several years ago in January. And while there, she got to know the girls who were learning to be leaders in their country, and she got to know the many teachers who were teaching these girls who were trying to be leaders of their country. And as this was all unfolding, fortunately, SOLA, the School of Leadership at Afghanistan, was able to get help from a number of people. But unfortunately, some of the teachers who had left the school were unable to get that help. And so we struggled for weeks working with the internationally known law firm of Gibson Dunn to try to get parole for some of these teachers and for others. We were fortunate in that one of the families we sponsored, a family of 8, was the only family out of dozens that Gibson Dunn worked with that we understand got parole, and they are still in Afghanistan today because they have been unable to get out. We were also aware of another family that was unable to get parole but managed to escape to Pakistan. And after escaping to Pakistan, due to financial reasons, despite the great danger to their family, had to return to Afghanistan and are still in danger. We also had another friend, a very close friend of my wife's, was a journalist who went to Middlebury College. And he was texting my wife. I remember sitting on our couch in peaceful Orwell, Vermont, one morning as we received text message, minute-by-minute updates of him trying to get out of the country, of him explaining to us what it was actually like in the throng of people in front of that airport. The relief that we had when we heard that he got through the gate, but also the horror in personally, my wife, I don't personally know them, my wife personally knowing people who were on the other side of that gate and who still are suffering under the Taliban's rule. So I just wanted to rise and tell that story and encourage my fellow members to vote in favor of this resolution because people's lives are at risk. We have a responsibility. That's why this was passed in the first place on the federal level. And we have to encourage our government to help these people because I'm hearing firsthand what it's really, really like, and it's not good. Thank you.
The question is, shall the resolution be read a third time? Are you ready for the question? If so, all those in favor, please say aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and third reading is ordered. Members, at this time, we are going to recess, and we'll be gaveling back in at 3 p.m. for any further business we may have. So with that, the House will stand at recess until the fall of the gavel at 3 p.m.